All right, everybody hear me?
Good morning, Your Honor.
Yes, Your Honor.
Good morning. So as I understand it, the first matter before the court today is Paul Williams versus Toms River et al. This is docket L555-24. This is an order to show cause, as I understand it, an action in lieu of prerogative risk, where the plaintiff is seeking certain injunctive relief and declaratory relief. I want to begin by having the parties enter their appearance, beginning with plaintiff's counsel, or plaintiff, actually, he's pro se, I believe.
Yes, Your Honor. Paul Williams. I am the plaintiff and I am proceeding pro se.
Morning, sir.
Good morning.
All right, so we have Toms River counsel, Mr. McGuffey.
Good morning, Your Honor. Greg McGuffin, Dash B. McGuffin, Nick Nichols. Yeah, listed in it. All right. Connor Anthony Buckley, I confirm name, for Toms River Township.
All right, anyone else going to enter their appearance?
Sure, Your Honor. Kelsey McGuckin Anthony with the same firm for the same defendant.
All right, good morning.
Good morning.
Good morning, Judge. Peter Pascarello on behalf of Toms River Township as well, but I'm really here for observation purposes, Judge.
All right. Good morning to all. All right, Mr. Williams, this is your application, sir. I'll hear you.
Thank you, Judge. Good morning. As the court has noted, I have filed a complaint commencing this as an action in lieu of prerogative writ with temporary restraints, the application that I've made. And I would like to briefly just hone in on what's really very fundamental about this matter, Judge, and that is the New Jersey Public Meetings Act, when it was created, established essentially a state-created right for the citizens to have some transparency with public bodies, and as it relates to this matter, a municipal governing body. And in order to facilitate that right, it requires that the governing body provide adequate notice of its meetings and, to the extent known, the agendas. It created the right that the public also has the right to be present during those meetings. The public has a right to observe what its government is doing. And it also prescribes that the governing body set aside a portion of those meetings for the public to be able to comment. But going back to the first issue, Your Honor, the issue of notice, and very clearly the statute does not require mere notice, but adequate notice. And in this case, the defense has presented what it published as notice of these meetings. And when I say these meetings, I'm referencing the subject meetings of January 18th and as well as February 14th. The defense has also presented, and I believe I presented it, the ultimate agenda of the meetings on the day of, which candidly, frankly, far exceeds what the public was provided notice of. Multiples of matters that were arguably routine that could and should have been known were included at the last minute, were not contained in the notices that were published in the newspapers.
Let me just stop you for a moment. I think we could probably get to the issues a little quicker. I've read all the papers and I think I'm familiar with the issues. Your papers were very good.
Thank you.
So let's get the specifics of January. Let's take the January 18th meeting. What is, in your view, what was needed in that agenda, in that be adequate. You compared it to the agenda that was prepared for the meeting that night. And looking at it, it looks like there's a list of everything that's on. What is it that you think that should have been added?
Okay, that's actually a good question. I believe that all of the matters that ended up on the January 18th meeting agenda the day of, not even, for example, posted on the municipal website, where up until the current administration, they were always published. They've been, the residents of Toms River have grown accustomed to being able to resort to the website. But I'm not going to go too far down that road, Your Honor. The fact is, to answer your question, minus some extraordinary reason for an exception, I believe that all of the items that ultimately appeared on the January 18th agenda, the day of, should have been included in the notice that was published in the newspaper. Now, to be very clear, Your Honor, because I'm cognizant that there is a cost for these publications, I am not suggesting that word for word the agenda items that appeared on the January 18th agenda should have been published previously, but something more than, in fact, since there was a lot more than what was published in the for publication for the January 18th meeting. We have a whole litany of things, and I don't have it immediately handy, Your Honor, but there's a whole litany of the things that were thrown in on the agenda on January 18th. In particular, one in particular, and I can mention this one because I'm very familiar with it, is this agenda item that that claimed to amend and supplement parts of the municipal code with regard to our police department. That could have meant anything. There was no notice that the proposed ordinance or the intent of that ordinance was to reduce the amount of personnel in the Toms River Police Department. And we did not become aware of that until 2 days before the hearing, 2 days before the meeting.
Which meeting are we talking about? February 14th?
No, Your Honor, we're talking about January 18th.
Okay.
That was when that particular ordinance was included on the agenda. Actually, I misspoke, Your Honor. It was not even included 2 days before the January 18th meeting. It was included, posted on the municipal website the afternoon of the January 18th meeting. And it made it simply, in very vague terms, referenced that they were going to supplement and amend the various parts of the municipal code pertaining to our police department. The rumor that we had heard was for about maybe a week earlier, or maybe several days earlier, from the January 18th. But that's just one of the many, because, Your Honor, if you look at the ultimate agenda for January 18th, there's a whole lot more than what was published in the newspapers. And certainly, I don't think that the intent of the legislature was, when they spoke about, to the extent known, the agenda, particularly giving their overwhelmingly clear intent to provide greater transparency to the people, that their intent was to create this loophole, if you will, for governing bodies to just put some stuff out and then claim that it was only to the extent known and shove it all in at the very last minute. I think that it's a misrepresentation. It's a deliberate attempt to conceal from the public what the governing body is going to be considering. And that's what in large part, what drew my ire about the manner in which these meetings were conducted. But I'm not sure if I had answered your question adequately, Your Honor.
Yeah, that-
Okay,
that's
so
fine.
with
You continue, I'm sorry.
thank you, Your Honor. I thought you were contemplating my my long-windedness, but in any event, Your Honor, with regard to the contention that there was not adequate notice provided to me and particularly as I am aggrieved by it, but to the public generally, that this was not conformity with the Open Public Meetings Act. As I read the certification from the council president, Mr. Coleman, and I would submit, Your Honor, that it's on its face, it's unbelievable that the items on the agenda for January 18th as well as February 14th, at least in more detail than what was published, that neither he nor the council or whoever was going to be responsible for preparing that agenda, that they didn't know, that it was to the extent known that they published the agenda, and then somehow, since it was published, they come up with all of these other things, which I'll concede one thing, Your Honor, that, and this would just be frankly good governance, that if there was some emergent matter that needed to be included on the agenda, I'd have no argument there. But these were don't appear to be emergent matters. These were matters that probably were more routine, or that could have been added onto the next agenda meeting, where there would have been public notice of those matters. But instead, the defendants in this matter, I believe surreptitiously and with a nefarious intent, sought to do a little trickery with what the council was going to be considering at those meetings. And I'm trying to stay within the realm of the evidence that I've submitted, Your Honor, instead of talking about things that I have not presented to you in terms of evidence. But with regard to the certification of Mr. Coleman, I would ask the court to take note that there's a serious credibility issue with regard to the assertions of Mr. Coleman. And the credibility issue arises with regard to my second issue, which was the basis that I was removed from the February 14th meeting. In Mr. Coleman's certification, he certifies under penalty of perjury that I was warned by him several times. I provided, Your Honor, with my certification, which attested that there was a brief, and contained within that brief there were allegations of facts and circumstances, and to the extent that those allegations were made on personal knowledge, that they were true and accurate. And in there I recited my version of what I've been able to transcribe from the pertinent portions of the meeting. And if Your Honor had the time to review that, you would know that at no time whatsoever did either Mr. Coleman or any other member of the council or any person whatsoever say anything to me that I was out of order, that I was being disruptive, and or that if I did it again I would be removed. I provided, Your Honor, with a link to the video of the meeting, and there in it, there's audio, and it shows, and it demonstrates what I did say and what was not said to me. And the fact that Mr. Coleman was tapped on the shoulder by a gentleman who pointed at me. Mr. Coleman leaned forward and demanded that the officers remove me from the room. There was never any warning. There was never any warning, despite the claim in Mr. Coleman's certification, which the evidence, the video, makes very clear is a lie in no uncertain terms. And I would ask Your Honor to take that into consideration as you gauge the credibility of Mr. Coleman in terms of whether or not the items listed on the agenda, to the extent known at the time that they were published in the newspaper, were the items that they were aware of. I would ask Your Honor to discount Mr. Coleman's claim and find that it's not credible. It's simply not. And candidly, I would ask the court to also look at those items that were ultimately placed on the agenda and conclude that those items were probably known. Were probably known at the time that the original notice was published. They knew. They at least maybe had an idea. And in that regard, the public was denied, I was denied, of adequate notice of the matters that the council at both the January 18th and the February 14th meetings was going to consider. That's the core of my argument, Your Honor. I did take note that in the responsive pleadings by Mr. McGuckin, that he claimed that I was trying to make the, for lack of a better phrase, the violations of the municipal code something that's judicially actionable. And that's, I want to clarify something, Your Honor. That's not what I claimed. I was simply suggesting and presenting the portions of the municipal code in terms of guidance for the court to understand that the violations, which by the way they do not deny, the violations of the municipal code that they do not deny, that the intent of those was to facilitate parts of the Open Public Meetings Act. And not only did they violate the Open Public Meetings Act, but they also violate their own rules. And that is why I have gone through the expense and the time and the energy to bring this action, to seek judicial redress. Because this council, this new administration, needs to know that the Open Public Meetings Act is not mere dry ink on paper. It has meaning, and it's imperative. I won't go into facts and circumstances that are outside this record, Your Honor, but I would submit that things that are going on at this time are only getting worse. One thing that I can suggest, Your Honor, is that, and I don't know if Your Honor wants to take evidence, but I would attest under the penalty of perjury that the afternoon that you signed the order to show cause, later that afternoon, an early evening, I went to another council meeting. And under circumstances very, very similar to the February 14th, I was again removed from another council meeting. Very similar to the circumstances alleged with regard to the January 18th and the February 14th meeting with regard to notice. There was no notice. There was no timely notice, there was inadequate notice, but that may be the subject for another matter. But I say this, Your Honor, because I am very cognizant that the relief that I am requesting is an extraordinary relief. It is the relief that is required by the law. It's the only relief. That any actions taken by the council at meetings that are not in conformity with the Open Public Meetings Act shall be void. It's my understanding, Your Honor, from the case law, that the courts have had some inclinations, typically not with municipal governing bodies, but with other boards, quasi-public boards, etc., that perhaps the inadequacy of the notice or something to that effect was maybe an isolated incident, maybe due to some extraordinary reason. But in those cases, the courts did not rule that the actions were voided, but they did provide some other forms of relief, such as injunctive relief, that directed the municipal governing body or whatever body that it pertained to. In this one, we're dealing with a municipal governing body, that it had issued an injunction constraining that body from further violations of the Open Public Meetings Act. But I think we'll get there at another point, hopefully today. The last thing that I want to touch on, Your Honor, is as I think that we're all familiar with, the Crow factors, the factors that govern typically whether or not the court should grant injunctive relief. If I could just have a moment to grab my note. I'll go right into my brief. As the court is aware, certainly, the New Jersey Supreme Court case, commonly known as Crow, requires that the court consider several factors. The reasonable probability of success on the merits of the underlying legal claims. Your Honor, I think that it's very clear that there is a likelihood, at least a reasonable probability of success on the merits of the underlying legal claims. With regard to both the January 18th and the February 14th meetings, I think that it's clear that the council has failed to comply with the Open Public Meetings Act in terms of providing notice. That the notice that was provided was, in fact, inadequate. The second factor is that such relief is necessary to prevent immediate and irreparable harm. I took note that the defense had suggested that there was no irreparable harm. I am unfortunately very familiar with the fact that a violation of any person's or even a chilling of a person's First Amendment rights is irreparable harm. The actions that this council has taken with regard to removing me from the meeting clearly constitutes irreparable harm. There's no harm that's going to be done. And the fact that, and I'm only suggesting this to Your Honor, and I did so, and I stated so under the penalty of perjury, the fact that the council had ordered me removed again at its meeting at the end of February demonstrates or compounds the demonstration that relief is necessary to prevent immediate and irreparable harm from continuing to happen to me or any other member of the public at the behest of the council president, the mayor, and other council members. The third factor, the legal rights underlying the moving party's claim are settled. The legal rights are spelled out in the Open Public Meetings Act, Your Honor. Can't get much more settled than that. And then four, the balance of harms favors the granting of preliminary relief. The defense has suggested that, on balance, suggesting that the administrative things that are a consequence of their violation of the Open Public Meetings Act, that weighs against the harms that I and other citizens are facing by this administration and by this council. Any of the harms that the defense may suffer, and particularly those that they spelled out in their responsive pleadings, the onus for that is on them. That has nothing to do with me. Other than I sought redress from the court for what they did. And they appear to continue to be doing. Maybe they need better legal counsel. Someone that's going to pull them by their coat and say, you're not allowed to do this. This is what has to be done because it's the law. The council, the mayor, must conduct meetings in conformity with the law. And they have not done that. And they do not appear to be poised to do it in the future. And there is one other thing. In addition, where the public interest is at issue, the court should also consider the effect of granting or denying injunctive relief will have on the public interest. If Your Honor were to deny the relief that I'm requesting, I can't imagine. You can't imagine what signal that would send to both the council, the mayor, and to the public with regard to how do we get redress from the court when we are not getting adequate notice. When the members of the public who will call out a mayor who himself is speaking out of order. When someone says, you can't speak. You can't speak. Dan Roderick, you're not allowed to talk unless you've been acknowledged by the council president. And then on the basis of that, and only on the basis of that, the person is removed from the public meeting. It's a scary proposition, Your Honor. It's scary. It chills First Amendment. The relief should be granted. It should be granted as a matter of law because that's what the statute provides for. It's the only relief that is required. And candidly, as a active member in this community, it's very unfortunate that there is going to have to be, if the court were to grant the relief that I'm asking, that there are going to be ramifications, things that have to be redone, perhaps other implications. It's unfortunate as someone that cares about this community. But it has to happen, Your Honor. I implore this court to seriously consider what the messaging is if the court does not grant the relief that I am requesting. On that, I would submit, Your Honor, unless you have any further questions of me.
All right, so let me just, before I go on to Mr. McGuckin, let me just ask a couple of questions based on comments. So you indicated that your familiarity with the Crow factors, and in familiarity with the Crow factors, you understand that, as you've indicated, it's an extraordinary remedy that you're asking for. And as a result, the law requires that you demonstrate these Crow factors by clear and convincing evidence. That's a high standard. In commenting on the standards, you were talking about the adequate agenda and the idea of the violation of the Open Public Meeting Act as one of those, applying to one of those prongs of Crow, which it does, an important prong. But what you're asking the court to do is to find that there was no adequate agenda because the council probably knew that there was more that should have been added on the agenda, and that you're asking me to apply negative credibility findings to a certification in order to do that. You recognize that's a big ask.
I do, Your Honor.
At this early stage, it's a big ask. I mean, to look at a certification and say, I'm making an adverse finding as to credibility as to someone, and particularly in the case, while I'm on the topic, and I guess I'll ask you to comment on it, in the passage of an ordinance, there is so much required with regard to notice and publication with ordinance. This was the first reading on January 18th, as I understand it. And I'm saying the ordinance. I think the primary ordinance that everyone, or that you're concerned with, and it seems like the faction that you represent is concerned with, has to do with the police department and not filling those spots and replacing them with EMTs. And I'm discussing it broadly. There's many more details, but essentially, I think that's it in a broad term. This was the first reading of that ordinance. Subsequently to that, there was a notice of second reading, which provided specific summary of the ordinance and when, February 14th, when that ordinance was going to be read, the final reading. And at that publication, that was on February 7th, as I recall, that also noticed the February 14th meeting that this would be the final hearing. And then at the February hearing, there was another notice 2 days before that indicated generally a listing of the things that would be on that agenda. So under the circumstances, is there a sufficient, first of all, is there a sufficient violation in your view? And can you explain to me why there is of notice under the Open Publics Meeting Act where somebody didn't appear? It seemed like I watched the video. It seemed like there was a lot of people there. With all of these notices, what is the risk that someone didn't know that this ordinance was being going to be discussed and the final reading was going to be at that February 14th meeting? These are just questions I have because at this early stage, you're asking me to do so much extraordinary remedy that I'd like to give you an opportunity to comment on it before I hear from Mr. McGovern.
Thank you, Your Honor. Your Honor, ideally, I would have liked to have been able to have an evidentiary hearing in this regard, especially after I saw and received the certification in the defense's response. I'm almost entirely certain that I would have been able to meet the clear and convincing threshold had I been able to cross-examine Mr. Coleman in particular, with regard to his claim that the items on the agenda were to the extent known. There's a part of me that even wonders if Mr. Coleman ever had any idea of what was on the agenda until it was put in his hand the day of the meeting. But nonetheless, even though that's, according to our municipal code, it's Mr. Coleman's responsibility to approve the agenda. But nonetheless, Your Honor, I appreciate your observation with regard to the first and second readings and who may not have known, etc. And I have to be very clear about one other thing. The matter with regard to the police department, I don't represent any faction in that at all. I have been involved. I've been part of some of the discussions, but I've kept my distance from that to a degree. But in any event, my concern is that both I want more people in our community to attend these meetings. I want people to understand that, that's our government and we need to be there. But in order to facilitate that, I think part of that is that we need to have adequate notice of what the council is going to be considering. And I don't think that we got there with this. Now, perhaps, let me answer it this way, Judge, and I apologize. I don't get to do this as often as Mr. McGuckin and Mr. Pasquarello do, but.
Yeah, you're doing a fine job.
Thank you, Judge. When I say the agenda, I'm referring to, when I say the ordinance, I'm referring to, as you noted, the police ordinance, okay? But for me, it's broader than that. It is all of the items that were on the agenda. The one involving the police department is just one that I was a bit more familiar with than the others. But in terms of who would not have had known, I can submit to Your Honor that we have over 70,000 registered voters in Toms River. And on a very regular basis, only about 25% of them vote. Which indicates to me, and there's a word for it, that signals to me that most people aren't paying attention to what's going on in our government. They will operate in the process that someone's taking care of it. But I think that if there was adequate notice of meetings provided, and particularly with this one on January 18th, that we would not have been scurrying, and I say we collectively, the people who were concerned with the ordinance, the police ordinance, that more people would have shown up on January 18th. But we didn't know about it. We didn't understand what was going on. We did not have adequate notice leading up to January 18th of what the council was going to be considering, particularly with regard to the police ordinance, but also with regard to all of the other matters. And, it's interesting that, I had suggested, in fact, I even said it to the mayor at one time. I had said, had you not put the police department on the radar within 3 weeks of getting sworn into office, you could have done all kinds of things and nobody would have known. But the fact that he put the police department on the agenda in that way, brought out quite a bit of people. And, but for that, it would have been the status quo. And so, and I think this is a long way of answering your question, Judd, about, who wouldn't have known? Well, nobody would have known. But that there was a lot of people there. The room only holds, I think, a little less than 250 people. And it was a packed house. And the court may be able to take judicial notice that it was such a packed house that the next meeting was supposed to be by way of Zoom on January 31st. And I don't know if Your Honor happened to notice, through the newspapers or whatever, that you'd be able to take judicial notice of, but the January 31st meeting did not go well and in fact was canceled. And then there's the second reading of the ordinance, the one with regard to the police department. But once again, there was a number of things that were included, not just the police ordinance, but that were included on the February 14th meeting. But let me also remind Your Honor that with regard to me, and this is, I think the timing of me being removed from the meeting is critical to the actions that the council took on February 14th. I was removed from the meeting practically from the very beginning. I was removed from the meeting before what we've been referring to as the police ordinance was considered, prior to there being public comment. I was denied the opportunity to provide a public comment with regard to that ordinance. And so whatever, I mean, if Your Honor were to say, the January 18th, and I appreciate your observations on that, Your Honor, and that's why I wanted to take this opportunity to point out about the February 14th, that, let's say if Your Honor were not to find that there was a violation of the OPMA, or otherwise that the relief that I'm asking for, that I've not met the burden. But with regard to the February 14th meeting, regardless of notice, I was removed from that meeting. And that is indisputably clear and convincing evidence that the OPMA was violated, that the defendants violated it, and that whatever actions the council took on February 14th absolutely must be voided under what some might see as a very simple thing, but it's not. It's a direct attack on the OPMA and a member of the public's right to be present, to observe what our council was doing, and to be able to make public comment on a matter that the council was going to consider and did consider. Other members of the public got to hear it. And And there were other things that happened. I would ask the court to take judicial notice of them. Things that happened after I was removed from the meeting. The exchanges between a member of the public and particularly the mayor. The
I
mayor,
object, this is not before the court, and he's actually gonna take judicial notice of something, I don't know what he's gonna say next.
Your Honor,
Right.
Your Honor, if I may.
Take judicial notice, it's a difficult thing. You see it on TV where you ask the court to take judicial notice, actually a difficult thing. It has to be something that really is non-contested. So what you're gonna comment on is probably not something I could take judicial notice on, but I'll let you make some comments on it. Go ahead.
Your Honor, and that, the video is pretty long, it's of several hours. I provided you with that link for this very specific reason, so that I can speak on those matters. Okay? The exchange towards the end of the meeting, or after I was removed, with regard to a member of the community, Phil Brilliant. An exchange, and that exchange between Phil Brilliant and was with regard to the mayor. Mr. Brilliant was also removed from the meeting, again, without any notice, and after being attacked. If Your Honor were to hear that, and I'll submit, Your Honor, timestamp 3 hours, 26 minutes, 49 seconds when Mr. Brilliant went before the council. Excuse me, he went before the council at 3 hours, 22 minutes and 5 seconds. At 3 hours, 26 minutes, 49 seconds, Mr. Brilliant said, "I asked for the resignation. I got crickets. I got no response." I then added, and he was then interrupted by the mayor. Keep in mind, Your Honor, the beginning of the meeting, I was thrown out of the meeting. I was removed from the meeting for simply saying, "You can't talk, you can't talk, Dan Roderick, you can't talk without being..." I was thrown out of the meeting for that. And
Well, actually, what you said was, everybody's out of order, I'm out of order too. I could be out of order too.
Your Honor, you're correct that I did say that. That was what I said, and I said some other things, and I think an expletive here or there is what I said after I was ordered removed from the meeting. The decision to remove me from the meeting was based on, I don't know what, but what I did do was I said, "You can't talk, Dan Roderick, you cannot talk without being acknowledged." And now I'm making an effort to contribute to this meeting getting back in order by directing that the mayor, this isn't the mayor's meeting, this is the council's meeting, by directing that the mayor can't talk because the council president wasn't doing it. But
So what would happen if everybody in that every 250 persons in that room did what you did? Would anybody be able to be heard? And the question is, does the president of the council, does he have an obligation to conduct or a right to have an orderly meeting and to do things to make sure that there's an orderly meeting? And does your speaking up violate that?
So, if everybody in the room did that, I think the council would know that they need to take serious inventory of themselves and conduct a better meeting. Number two, I agree with you. Absolutely, the council has a duty and a responsibility to maintain decorum in the meeting, throughout the meeting, etc. In fact, I took particular notice of something that the council president had said. I've been going to meetings for years, and I've never heard a council president say it. But this council president makes an opening statement, if you will, that talks about how the meeting is going to be conducted. And he says clearly that if you, something to the effect that if you don't respect the person or if you're interrupting, you'll get a warning. And if you persist, you will be removed from the meeting. And then and what I find very, very interesting, and I have yet to see him implement it, is that he says this applies to the council as well as the public. And because this is a council meeting, the public includes the mayor, because it's not his meeting. This is the council's meeting. But yet and still, you can watch that video, Your Honor. I won't belabor you with it. But the fact that...
While we're on the topic, You said that in that initially there was that statement by the council president. But you indicated that the January 31st meeting didn't go well and had to be canceled. What happened there?
So,
What's that?
it was one of the most bizarre things that I've ever seen at a public meeting. It was a Zoom meeting. In fact, what did happen, and I provided a 24-foot inflatable screen with a projector in front of town hall for about 200 people that were in front of town hall, so that we could all watch this meeting by way of Zoom. What did happen was that many people tried to log in, including myself, and that as we attempted to log in, that the meeting had already reached capacity at about 500 people. And as that meeting was progressing, or attempting to progress, there was a moment where I think the floor was opened up for public comment, and however it happened, one of the people on this Zoom meeting had said something of some bizarre nature about people of a particular religious group and babies, and something about New York and tunnels, and next thing we knew, the meeting was cut off. And myself and several other people, we were so in shock that we laughed because of the ridiculousness of it. Like, our council was not prepared had no idea how to conduct a meeting in person, let alone by way of Zoom. Like, that was just going to be a disaster. We knew it was going to be a disaster because it had to be. But that comment that resulted in the meeting getting disconnected was just icing on the cake. It's like, that's just how bizarre our local government is right now. I turned around and I saw a couple of off-duty police officers, and I said, this is real life. This is our government right now. The absurdity.
There was a disruption. There was some disruption by somebody said something and it had to be ended.
Yes. Essentially, yes.
All right.
So,
Anything else, sir?
yes, just briefly, Your Honor. Your Honor,
Okay.
just to, for your reference, I'm going to ask Your Honor to take note of the video. Timestamp 3 hours, 26 minutes, 49 seconds. That was a grotesque exchange with the mayor interrupting a member of the public. If Your Honor would be so inclined to take note of it, multiple times, Mr. Roderick is antagonizing this member of the public. This went on for this went on for about 5 minutes, on and on and on. Even Mr. Roderick, our mayor, had even suggested that the person should resign, antagonizing him, saying, run for office or resign from the Municipal Utilities Authority, run for office, just in an antagonistic way, which ultimately resulted in that person being removed from the meeting. I ask Your Honor to take note of timestamp 2 hours, 25 minutes, 44 seconds. That was an exchange with another member of the public, Jennifer Howe. And again, Mayor Roderick interrupting at 2 hours, 27 minutes, 44, and then started yelling at this woman that she's political grandstanding, again antagonizing a member of the public. There's other ones with a member of the public, Julie Adamick, Andy Dragg, an unknown individual, Your Honor, literally screaming, was never even given the floor, was not thrown out of the meeting. But I was. And that would have been at 1 hour, 39 minutes, 02 seconds. The gentleman walked up to the microphone without being acknowledged and was screaming random things at the top of his lungs. Was not removed from the meeting, but I was. Anthony Sergio, again, interrupted by the mayor. Jim Stegman, interrupted by Councilman Lobbin. David Paulus, again, interrupted, and it goes on and on. Your Honor, the point is that I provided Your Honor with the link to the meeting so that it would be part of the record, so that I could reference it in terms of evidence that demonstrates the tone of this council, of these defendants. That would be the township, the mayor and the council. The predisposition of this council and the mayor is to have no regard, no concern, and certainly no obedience to the Open Public Meetings Act, particularly the right of the people to have adequate notice of the meetings and the right of the people to be present during the meetings. With that, I submit, and I thank you, Your Honor.
All right. Thank you, Mr. Williams. Mr. McGuckin?
I thank you, Your Honor. I'll start with what I'm not going to address first, and that is I'm not going to address the ad hominem attacks upon myself as township attorney, the township law department, or Council President Coleman, which I find incredibly inappropriate for this proceeding. I would like to address the fact that, as Your Honor, I'm sure can appreciate, based on the comments of Mr. Williams, Mr. Williams simply believes he can do things better. He can run a meeting better, he can run a town better, and he believes he has that right to do so. Now, Mr. Williams had that opportunity at the ballot box. He was a candidate for council in the last election during the primary, and he was defeated. And he doesn't like the result. And he doesn't like the people who are running the township. He doesn't like what they're doing. And his remedy is simply at the ballot box, Judge. It is not to interrupt a meeting. It is not to cause chaos in a meeting. And it is not to simply sue because he doesn't like decisions that are made by the duly elected officials. Now, to get to the merits of the claim, as Your Honors can appreciate, and no one knows the joy of the fact better than Your Honor, based on your experience in country. However, I just want to point out, it's in our papers, in order to provide the 48 hours notice, we have to provide a list of items to be considered 3 days before that publication. And often that is 5 to 6 days before the actual meeting, because that's the paper's requirement, and it's our obligation to make sure they have the opportunity to publish 48 hours ahead of time. So when we're talking about what was known and not known, it's at the time the notice is sent to the papers, which is at least 5 days before the actual meeting. Second thing I'd point out is that if this had been a regular council meeting, there would have been no notice, and there's no legal requirement for any notice as to what would be on the agenda, neither on the website, on the township page, or in the newspaper, except for ordinances which are on for second reading, as Your Honor indicated, or for certain hearings that are required by law. In those cases, additional advertising is required. But regular meetings of the township, which are published at the beginning of the year, there's no agenda, there's no idea what's going to be on those agendas, and council is free to amend an agenda right up until during the meeting. And I've seen it happen where during the meeting, an agenda is amended, new items are considered. That's what the Open Public Meetings Act provides for. It's to provide the public the opportunity to observe and comment upon actions that are governed by. The things are not done in secret. That's the purpose of the Open Public Meetings Act. Now, when it comes to a special meeting, which was not previously noticed to the public, the township is required to provide such notice as they can of items to be considered. And it's a list, it's not the actual agenda, as we pointed out in our brief. It's a list of the items that are likely to be considered. That was provided for both the January and February special meetings. We submit that they meet the full requirements of the Honors Act case. We believe the township is absolutely acted appropriately. And we believe the case, we believe the township has properly complied with the Open Public Meetings Act. As Your Honor yourself indicated, the biggest issue here was the ordinance. And those ordinances on for second reading are required by another statute to be published at least 7 days ahead of time. And they were. So the public had full and fair opportunity to comment upon ordinances which require a public hearing, which is why they are required to be published before second reading. Those are required. Resolutions of the council, other actions of the council do not require public comment. That public comment can be at the beginning of a meeting, in the middle of a meeting, or at the end of a meeting, which is the way most towns do it, including Toms River. So ordinances require a public hearing. They have to be noticed separately, and they were. As far as the special meeting is concerned, the agenda, to the extent known, was clearly provided by the township. So I want to address the issue that Mr. Williams continues to harp on, and that is his removal from the meeting. First, I want to point out that 2 nights ago at the council meeting, Mr. Williams had the full opportunity to participate. He came up to the microphone, exercised his 5 minutes to speak about any issue he chose, and there was no problem. Why was that? Because Mr. Williams didn't interfere with the meeting. He didn't try to voice his opinion as to how the meeting should be run or who should be allowed to speak or not speak. That clearly resides with the council president, who presides over council meetings under this form of government. The council president is the one who's responsible to run the meeting. It's the council president's responsibility to ensure that that meeting can take place, that people are given the opportunity to be heard, and that the entire business of the township can proceed and continue. And when someone interferes with that process and tries to usurp the authority of the council president and determine who can speak and when, that interferes with the meeting. We submit it was intentional, whether it was or not. It's actually a criminal violation for that under 2C. And no one's been charged with a crime. Nobody wants to see someone charged with a crime. But you can't filibuster a meeting. You can't interfere with the meeting because you don't like where the meeting's going or what the decisions may be made. You have a right to comment. You have a right to listen to other comments, but you don't have a right to interfere with it. And that's what happened here, and that's why Mr. Williams was removed. Now, Mr. Williams believes his constitutional rights have been violated. As a result of that, he can pursue a federal action to do so. He can file a new complaint to say that his rights were violated. It's not a violation of the Public Meetings Act, and it's not been properly pled in this court. We would be glad to respond to any such allegations. We would remove the matter of federal court and make an appropriate motion to dismiss based upon the case law, allowing the council president to remove someone who interferes in the meeting. So, all of those factors considered, the most important question before the court is he entitled to injunctive relief today? And the answer to that question is a resounding no. What is the irreparable harm? As I said, you spoke the other night, there's no problem. There's no irreparable harm that he can point to, nothing substantial. There's no irreparable harm whatsoever. As far as the merits of the case, Judge, I think our brief clearly covers it, and I think I've addressed it already quickly in this argument. Under Underdeck, the township has fully complied with the requirement. Under Title 40, we've complied with the requirements for publishing of the ordinances and notice to the public with respect to same. And I simply reiterate that if this had been a regular meeting, there could be no agenda item that has to be published ahead of time. Nothing. And the Toms River Township from the past has, in fact, tried to provide at least 2 days' notice of when a meeting is going to take place and what may or may not be considered. They publish draft agendas if they wish to do so. That is not a legal requirement under the Public Meetings Act. And there's no requirement that the township do so under the statute. And if there's no requirement, there can't be a violation of it. So, with that said, the township will rely on the papers, our certifications, and quite frankly, the notices that were provided to the public. Thank you.
All right. I gave Mr. Williams an opportunity to comment on it. With regard to the special meeting notice for January 18th, you've indicated that there's no requirement. If you're aware that there'll be a first reading of an ordinance, are you required to put that in the agenda, on the published agenda?
Judge, if you know for a fact, if the council president knows that that is going to be considered, that would be to the extent known. It should be included in the notice that it would be on that an ordinance would be considered for purposes of discussion and introduction. I don't think you have to list the entire ordinance. You're not required to list every item that could be considered. Quite frankly, if you list ordinances for consideration for introduction, you fully comply with the statute.
With regard to a first reading of an ordinance, is there permitted public comment?
No.
So on that first reading, essentially it's read and there's no public comment.
That's correct, Judge.
And then subsequent to that, the final reading, there's a subsequent publication required by the statute, which was done here on February 7th, that requires a summary of the ordinance or publishing of the ordinance with the date that it's going to be finally read, and there is public comment at that time. Is that right?
Correct. That's the public hearing under the statute, and that's what was done here.
Right. All right. All right, Mr. Williams, anything else before I issue my decision?
Yes, Your Honor. Mr. McGuckin has essentially argued that when the council set its schedule of meetings on January 1st of this year, that it doesn't have to provide any other public notice with regard to the agendas. It tends to defy logic for me. But I look at the statute with regard to the definition of adequate notice. And in Part D, it defines adequate notice means written advance notice of at least 48 hours, giving the time, date, location, and to the extent known, the agenda of any regular, special, or rescheduled meeting. Take note, Your Honor, that it didn't just say any regular meeting, that it also included special or rescheduled. The intent of that legislative language is that anytime there's going to be a meeting, you can set a schedule at the beginning of the year and put public notice out to that, that's fine. But I submit, Your Honor, that the reading of that definition implies clearly that they do have an obligation, and in fact, the public has a right to receive adequate notice of at least 48 hours, and to the extent known, the agenda. That's Section D of New Jersey Statute, Title 10, 4-8. Adequate notice. That's with regard to that. I want to clarify something so there is no misunderstanding, that whether an item is on for first reading or not of an ordinance, that at the end of the meeting, towards the end of the meeting, there is a portion set aside for public comment. So for example, on January 18th, there was this one particular ordinance, the one pertaining to the police department. There may have been another, but in any event, there is public comment. There's a portion of the meeting, according to the statute, that requires that a portion of the meeting be set aside for public comment. Not necessarily limited to only the ordinance. In our municipal government, the way that we do this is that there's an ordinance on second reading, and then there's an opportunity for public comment. And there's also an opportunity for public comment on certain resolutions, etc. But just because, for example, January 18th, there's an ordinance presented for first reading, that doesn't mean that the public, at the end of the meeting, for generalized public comments, don't get to speak about that ordinance. It's absolutely incorrect. The public does. They just don't get to speak on the ordinance on first reading before the council actually votes whether or not to move it along to second reading. Now, at the time of the second reading, when the ordinance is presented before the council votes on it, there's an opportunity for the council members to comment on it, and there's an opportunity for the members of the public to comment on it. And then the council can vote. And then at the end of that meeting, the public again gets an opportunity for public comment. And they can speak about what the council just did. They can talk about anything else that any member of the public thinks is of public importance. Now, just to make sure that we're clear about that. The last thing that Mr. McGuckin said was that was in reference to me being removed from the meeting. He insists that I was disruptive. Your Honor, I may have been loud. My voice may have carried over others who were all arguing, making visceral attacks on each other and other people. And the council president, if you look at the video, is sitting back in the chair. He's just sitting there, letting all this chaos go on. And I observed, I believed, that a lot of it was being instigated and provoked by the mayor. And so I raised my voice as a concerned member of the public. Your Honor, had the opportunity to watch the video. You heard what I said. You heard what I did. Yes, my voice was louder than others. And it certainly got a lot of people's attention. So much so that someone had to tap the council president on the arm and point in my direction at me and say, remove that man. I wasn't given a warning. I was removed from the meeting. And then the council went on to do what they were doing. Mr. McGuckin also suggests that Now, he makes these arguments about, I ran for office and my recourse is at the ballot box, etc., or that I can file a lawsuit. Yes, I ran for office. Am I mad about it? Ron, I'm a Democrat. I'm on a losing team. I'm a Democrat in Towns River. I'm not mad. I expected to lose. I also expected my own party to lose. So there's no, I'm not mad about it. I expected it. But that does not dissolve my passion for my community and to support my government. When I lost the primary in June last year and Dan Roderick and his slate won, I went to the next council meeting and I implored the council members to acknowledge that unless my party got their stuff together and got it together really fast, he was going to be our mayor. And I implored upon him to take a serious inventory of why people don't like him. Because he's going to be our mayor and I want him to be a good mayor. So I don't go to these meetings with any anger or I'm mad or I think I can do it better. Candidly, given what I've seen in the last couple months, yeah, I can do it better. But that's not my litmus test. I'm not going to do it better. I want them to do better. And that is why I brought this action, Your Honor. I think that it is imperative for this court to take inventory of what it has before it. And I understand full well, Your Honor, that I'm asking for some extraordinary relief here. But the last thing that Mr. McGuckin said was that, I can also file a lawsuit in federal court, or we can move this matter to federal court. Yeah, isn't that nice for Mr. McGuckin to say, because his firm is the one that gets paid. He gets billable hours for this, Judge. I don't get any billable hours. I'm a photographer and videographer by trade. I don't get paid to do this. He gets paid to be here. I'm not paid to sit here right now and present this. I had to come out of my own pocket to file this action, $309. So Mr. McGuckin's suggestion that, that's the way to go, yeah, I bet he would wish I would do that. Because either way, he gets billable hours and he's good for it. That's it, Your Honor. Thank you.
All right, anything else?
No, Your Honor.
I should not respond to it.
All right. I'm sorry, you do not have a response?
No, I'm not going to respond.
All right, this is action in lieu of prerogative writs brought by plaintiff to void all actions taken by the defendant counsel of the Township of Toms River at both their January 18th and February 14th, 2024 meetings. This application also seeks injunctions to enjoin any further violations by the defendants, alleged violations by the defendants. The court finds the following facts from the statements and the certifications. And I will also note that the meeting was televised and shown to local residents. A videotape of the meeting was linked to the submissions provided to the court and was viewed by this court, not entirely. I only viewed the sections that I thought were pertinent to the application and comments by Mr. Williams with regard to what happened in 3 hours before us. I didn't watch however many hours there were in the tape. I just watched the pertinent parts, which was essentially the beginning up until Mr. Williams was removed. No official transcript of the meeting was provided. For the purpose of this hearing, the facts found by this court are in part derived from this court's partial viewing of that videotape, and are only for the purpose of this hearing. As these things develop, if this matter does continue, facts are developed, discovery is produced, the court will amend whatever findings attached here today to reflect that evidence as is found in the briefs. So, in any event, the court finds that the Toms River Township Council held a special meeting on January 18th of 2024. The Toms River Township Council also had a special meeting on February 14th of 2024 to comply with the Open Public Meetings Act, or the OPMA. On January 5th of 2024, the Township Clerk of the Township of Toms River contacted the Asbury Park Press and the Star Ledger regarding the publishing of notice of special meetings of the Township Council of the Township of Toms River. The notice appeared in the Asbury Park Press and the Star Ledger as follows. Take notice that the Toms River Township Council will hold a special public meeting on Thursday, January 18th of 2024 at 7 p.m. The meeting will take place in the L. Manuel Hirschblond Room in Town Hall, located at 33 Washington Street, Toms River, New Jersey, 08753. Items on the agenda include 1, second reading and public hearing of an ordinance repealing Chapter 253 of the Township Code, and 2, the interim appointment of the representative to fill the vacancy, Ward 2 count seat, official action will be taken. On February 6th of 2024, the Township of Toms River contacted the Asbury Park Press and the Star Ledger to publish a notice of special meeting to be held on February 14th of 2024. The notice of the special meeting held on February 14th, 2024 said as follows: please take notice that pursuant to NJSA 10:4-8B and D, the Township Council will be conducting a special meeting on February 14th of 2024 at 2 p.m. The meeting will be held in person in the Hirschblom Room on the second floor of the Toms River Township Municipal Building located at 33 Washington Street, Toms River, New Jersey, 08753. The meeting will also be live streamed on Township YouTube channel. The agenda shall include one final reading and public comment on ordinances pertaining to the restructuring of various departments, and two final readings and public comments on various traffic ordinances, and three consent agenda consisting of various purchases and other routine items of public business. Formal action may be taken. At the February 14th meeting, plaintiff was removed from the meeting after meeting with the plaintiff has since filed a within action. To summarize, plaintiff has alleged that the actions of the council did not conform to the provisions of the Open Public Meeting Act, NJSA 10:4-15, and New Jersey Court Rule 4:69-1. That is, council is alleged, is expressly required to provide at least 48 hours advance notice to the public of the time, date, location, and to the extent known, the agenda of the regular, special, or rescheduled meeting, which notice shall accurately state whether formal action may be taken or not taken. That's cited NJSA 10:4-8D by the plaintiff. The agenda, it also alleged by the plaintiff that the agenda for each regular meeting of the council shall include only such matters, council business, as have been presented or delivered to the clerk by council persons no later than the Friday preceding the meeting at 12 noon. And this is a site for the Township of Toms River's Municipal Code, Section 5(8)A. Where a special meeting called by mayor or for council persons, mayor shall designate the purpose of the special meeting, and no other person shall be considered, no other business shall be considered. And that's also Township Code, Section 5(7)B. On January, it is alleged by the plaintiff further that on January 9th of 2024 and January 12th of 2024, published notice of the special meeting to be held on January 18th. Designated purpose of the meeting simply stated as indicated items on the agenda. In any event, in summarizing, the plaintiff asserts that the notice was insufficient, that neither notice for the January 18th special meeting of the council contained any reference to the Toms River Police Department. Social media reports circulated, is alleged by the plaintiff, that council intended to take notice with regard to the police department. I'll note that it is referred to in the papers that essentially the mayor and council had believed and identified an issue with regard to sufficient numbers of EMTs and ambulances, and it was their intention to not fill certain retiring positions in the police department, take that money and use it for ambulance and EMT. On the morning of, and I would just say that for way of background, on the morning of January 18th, 2024, it is alleged by the plaintiff that the date set for the special meeting of council was to convene in the evening. In the afternoon, a proposed ordinance appeared on the agenda indicating that it was the ordinance, quote, amending and supplementing sections 50-3B, 50-3D, and 50-3R of the Township Code to revise the roster of positions within the Department of Law, without giving any indication of what was actually being amended and supplemented. At approximately 7 p.m. on January 18th, 2024, defendant, and this is, I think it's a misprint, but it's, I believe it's 2 p.m. on January 18th. Oh, no, 7 p.m., I'm sorry, I'm thinking of February 14th. 7 p.m. on January 18th, 2024. Defendant Coleman called a special meeting of the council in order a majority of the council voted yes and approved all items on the agenda. which is further alleged by the plaintiff that on February 12th of 2024, published notice of the special meeting of council to be held on February 14th. And purpose of the meeting simply stated, quote, the agenda shall include one final reading and public comment on ordinances pertaining to the restructuring of various departments, final readings and public comments on various traffic ordinances, and 3, consent agenda consisting of various purchases and other routine items of business, and formal action may be taken. Plaintiff asserts that the generic reference to restructuring of various departments, various traffic ordinances, and various purchases and other routine items of public business appear to be wholly inadequate notice to the plaintiff and other members of the public, and part of deliberate effort to prevent the public from knowing what defendants intended to do during the February 14th meeting. Plaintiff further asserts that the paper agenda for 2014 provided that afternoon consisted of 6 pages with a total of 8 ordinances for final reading and 28 resolutions. Plaintiff asserts further that at approximately 2 p.m. on February 14th, the defendant, Coleman, who is the council president, called the council meeting to order. And after several customary actions and then made a statement about having been given the responsibility to conduct a professional organized meeting without interruption, and in that regard announced, quote, any individual who do not show respect for the individual who has the floor by interrupting will be given a warning and will be removed from the room if the interruptions continue. This goes for council members as well as the public, end quote. Once Councilman Quinzlick was recognized by the defendant Coleman, Councilman Quinzlick raised a question of order about the propriety and legality of the meeting being proceeded with and without the question being answered by the council's attorney. He made a motion for the meeting to be adjourned. And again, these are allegations by the plaintiff. And I'll note, I'm going to summarize here, that essentially a discussion took place between Mr. Councilman Quinzlick and other members of council with regard to Township Code, previously cited, Section 5 of the Township Code, which requires certain notice and written notice and written contact with and calling a meeting with other councilmen or by the mayor. And there was questions about whether that was done. A vote was taken or a motion was moved by Mr. Quinzlick asking that the meeting be adjourned without taking any further action based on his allegations that these violations of Township Code took place. There was 2 votes in favor of adjourning the meeting. The motion did not carry, and the meeting continued. Based on these allegations, the plaintiff claims as follows: seeking certain declaratory relief that defendants have acted in violation of the Open Public Meeting Act, that defendant must act in accordance with the Open Public Meeting Act, for a temporary restraining order enjoining the restraining defendants from continuing with actions taken by the defendant at the council meeting on January 18, 2024 and February 14th of 2024 until further order of court, voiding all actions taken at the meeting that did not conform with the Open Public Meeting Act, and for fines, fees, and costs, including attorney's fees, and for other costs and relief. The defendants have responded and asserted essentially that in applying the Crow factors, which are required to be applied in this case, that injunctive relief is being sought pursuant to the rule, which cites the Rule 452-1, that no allegations of irreparable harm has been shown, that no showing of well-settled law or successive merits supporting the claim have been shown, that balance of the hardships do not favor issuance of the restraints. In order for plaintiff to obtain a preliminary injunction, he must demonstrate that there is a reasonable probability of eventual success in the merits of his claims in that Zoning Board of Adjustment versus Service Electronic Cable Television, 198 NJ Super 370 at 378-79, Appellate Division, 1985. Moreover, a preliminary injunction should not issue if the law on which the plaintiff bases his claim is doubtful or unsettled. And that's Accident Index Bureau Incorporated versus Mail, 95 NJ Super 39, page 50, Appellate Division, 1967, affirmed at 51 NJ 107 in 1968. The appeal was dismissed at 393 US 530 in 1969. See also Citizens Code Company versus Camden Horse Railroad Company, 29 New Jersey Equity 299 and 303 and 305, 1878. Nor will a preliminary injunction issue where the underlying material facts are in dispute. That's Sanders versus Greenland Corporation, 31 NJ Super 329 at 338, Transit Division 1954. Although an interlocutory injunction should not issue if plaintiff's rights are not clear as a matter of law or equity, an exception may exist where the subject matter of the litigation will be destroyed without the protection of such injunction. And that's General Electric Company versus Gen Vacuum Stores, 36 NJ Super 234, 237, Appellate Division 1955. Furthermore, the requirement that plaintiff must make a preliminary showing of a reasonable probability of ultimate success in the merits is, quote, tempered by the principle that mere doubt as to the validity of a claim is not an adequate basis for refusing to maintain the status quo, end quote. And that's Crow versus the Joy, 90 NJ 126 at 133, 1982. Lastly, the court must balance the equities involved and should it determine that the possible harm to defendant resulting from the issuance of an injunction outweighs that threatening plaintiff, should the injunction not issue, then plaintiff's request for injunctive relief should be denied. A party seeking the extraordinary relief of a preliminary injunction is required to prove each of these elements by clear and convincing evidence. And that's Garden State Equality versus Down, 216 NJ 314 at 320, 2013. Waste Management New Jersey Incorporated versus Morris County Municipal Utilities Authority, 433 NJ Super 445 at 452, Appellate in 2013. The court is required nonetheless to examine all the Crow factors and may impose a preliminary restraint even in the absence of a demonstrated likelihood of ultimate success in the merits if an evaluation of all the Crow factors on balance requires that the court act to prevent the destruction of the race of litigation. And that's Christensen versus Local 680 of North Drivers, 127 NJ, Equity 215 ENA 1940. As set forth more recently by the Appellate Division, this less rigid application of the Crow standards permits injunctive relief, preserving the status quo even if the claim appears doubtful, and a balancing of the relative hardships substantially favors the movement. The irreparable injury to be suffered by the movement in the absence of the injunction would be imminent and grave, and where the subject matter of the suit would be impaired or destroyed. And that's Waste Management versus Morris County Municipal Utilities Authority, Supra 433, NJ Supra at 454. As indicated, the seminal case in determining whether the court should grant preliminary injunctive relief is Crow versus the Joy of Supra. Under Crow, the movement must demonstrate by clear and convincing evidence, first, that irreparable harm is likely if the court denies a preliminary relief. Second, the applicable underlying law is well settled. Third, the material facts are not substantially in dispute, and there exists a reasonable probability of ultimate success in the merits. And fourth, the balance of the hardships to the parties favors the issuance of the requested relief, and that's it at 132 and 134. The relief granted should be no broader than necessary to preserve the status quo pending a preliminary hearing on the merits, at 135. The burden on a party seeking a preliminary injunction is, quote, particularly heavy, unquote, and that's Ronaldo versus RLR LLC, 387 NJ Super 387 and 396, Appellate Division 2006. When limited to preserving the status quo with lawsuits pent during the lawsuit's pendency, a court may, quote, place less emphasis on a particular Crow factor if another greatly requires issuance of the remedy, unquote. And that's Waste Management New Jersey versus Union County Municipal Utilities Authority, 399 NJ Super 508 at 520, Appellate Division 2008. Under the first Crow factor, the movement must show that preliminary relief is necessary to prevent irreparable harm. That's Crow Super 90 NJ 132. See also Subcarrier Communications Incorporated versus Day 299 NJ Super 634 638, Appellate Division 1997, where the court explained injunction may issue when needed to prevent substantial immediate and irreparable harm. Ordinarily, no preliminary injunction will issue unless plaintiffs have no adequate remedy at law. And that's Green versus Piper, 80 New Jersey Equity 288, Chancery Division 1912. Plaintiff must be threatened with substantial, immediate, and irreparable harm if the preliminary injunction does not issue. And that's Crow Super 90 NJ at 132 and 133. Ordinarily, harm is considered irreparable in equity if it cannot be redressed adequately by monetary damages, and that's Crow Super 90 NJ at 132. However, in this case, the plaintiff need not show irreparable harm to be entitled to injunctive relief, where injunctions are creatures of statute All that need be proven is statutory violation of the statutory mandate constitutes irreparable injury per se, and that's under the Open Public Meeting Act. And what I'm quoting from is Madawan Regular Teachers Association versus Madawan Aberdeen Regular Board of Education, 212 NJ Super, 328, 335, Superior Court, 1986. Internal citations omitted. I will also note violation of First Amendment rights are also considered irreparable harm. So the question, therefore, is whether there is sufficient evidence of a violation of the statutory mandates or constitutional right, either Open Public Meeting Act or the First Amendment, that would bring us to the next prongs of Crow. So if showing that there's a violation, clearly there would be irreparable harm shown. The question is, and I think the difficult question for plaintiff, is the allegations of violation. The Open Public Meeting Act obliges public bodies to provide, quote, written advance notice of at least 48 hours, given the time, date, location, and to the extent known, the agenda of any regular, special, or scheduled meeting. And that's NJSA 10:4-8D. The Open Public Meeting Act defines adequate notice as, quote, written advance notice of at least 48 hours, giving the time, date, location, and to the extent known, the agenda of the regular special meetings, rescheduled meeting. And again, that's the NJSA 10:4-8D. An agenda, as the term is used in the Open Public Meeting Act, is, quote, a list or outline of things to be considered or done, end quote. And that's, quote, from Overbeck versus Midland Park Board of Education, 442 NJ Super, 40 and 56. Appellate in 2015, where it used the ordinary definition found in Merriam-Webster's full definition. However, quote, where annual notice or revision thereof in compliance with the statute set forth the location of a meeting, no further notice shall be required for such meeting, and that's NJSA 10:4-8D. This is a special meeting, so publication of the agenda was required. It is this court's view that plaintiff has not clearly demonstrated that the agenda did not include what was required in the law. A list of or outline of things to be considered or done as known at the time. The plaintiff has asserted and explained during his argument, and I'll say that his papers are very good for a pro se for anybody. They're very good. And his arguments are very good, but candidly, he acknowledges that in order for the court to find that there's a violation of the agenda, the court must find that there was insufficient adequate notice known at the time, as pointed out by Mr. McGuffin. These notices are provided some 5 days in advance to beat the 48-hour deadline. And under the circumstances, as acknowledged by Mr. Williams, that the court would be required to apply a credibility finding to Chairman Coleman's certification. That is, Chairman certified that this was known at the time the agenda was filed and published, and that Mr. Williams has asserted and argued that he probably knew more, and that this court should find his testimony or his certification credible. Under the circumstances, given the high burden that is required for the plaintiff to demonstrate at this stage of the proceedings under Crow, that is clear and convincing evidence, the court is not willing to take that step and find somebody not credible at this early stage. Under the circumstances, there were general reference, moreover, there were general reference to what was going to be done, there could be official action going to be taken, and the first reading ultimately was made with regard to it. And I should say that there's a lot of things that Mr. Williams has indicated that he has concerns with, but I think that everybody recognizes the primary concern had to do with this, I refer to as police ordinance, which was its first reading on January 18th. For those reasons, this court's view that the plaintiff has not clearly demonstrated that the agenda did not include what was required under the law. In addition, I would also indicate that there were different subsequent references. Now, there was also allegations that the February 14th meeting wasn't properly noticed as a special meeting. The ordinance were referenced in the February 7th notice of final reading with summary and cite to the Township Code. The January strike that the ordinance, the notice of ordinance to be finalized on 2/14 was published on 2/7, and I'm not going to read all of the ordinances. I will read the one that seems to be the subject of this application. But the ordinance read in pertinent part as follows: Toms River Township notice ordinance of the Township Council of Township of Toms River, Ocean County, New Jersey, amending and supplementing sections 50-3B, 50-3G, and 50-3R of the Township Code to revise the roster of positions within the Department of Law Enforcement. Purpose: amending and supplementing the aforementioned sections, and that's my insert, they actually cite the sections, of the Township Code to revise the roster of positions within the Department of Law Enforcement. And then it goes on and talks about notice will be given that to be taken at the meeting, but it also indicates that the hearing, the final reading will be held, that the initial reading was held on January 18th of 2024 at 7 p.m., and that the final reading will be held on February 14th, 2024 at 2 p.m. So there is an additional notice, in addition to the 48-hour notice which was subsequently provided to the public, that Mr. Williams contests was insufficient. I'll note that notice of agenda requirements under the Open Public Meeting Act as it pertains to ordinance approval has been addressed by our courts interpreting the provisions of NJSA 10:4-15. See County of Monmouth versus Snyder Westerland Corporation, 156 NJ Super 188, 192, 193, called version 1978. The so-called, quote, last proviso clause, end quote, contained in NJSA 10:4-15 reads as follows, quote, and provided further that any action for which advance public notice of at least 48 hours is provided as required by law shall not be voidable solely for failure to conform with any notice requirement in this act, end quote, id. As succinctly explained by the court in Snyder Westerland, quote, the last proviso clause was intended to apply to a situation where the published agenda was inadequate. The last proviso clause in NJSA 10:4-15A did not appear in the original bill of the proposed Sunshine Law introduced in the Assembly on January 28th of 1974, nor did it appear in the first official reprint of the proposed act. It first appeared in a second official copy reprint where it was accompanied by the following explanatory statement. Section 10 also provides that in actions such as an adoption of an ordinance where there has been advanced published notice of at least 48 hours shall not be voidable solely for failure to conform with notice requirements of the Act. Thus, it is obvious that the purpose of the clause was to avoid duplication of notice in instances such as the adoption of ordinances which, by their own procedure, require published notice before consideration. And that's City of Monmouth versus Snyder Westerland Court, 156 NJ Super 188. And that's a quote from pages 192 and 93, Appellate Division 1978. The last proviso clause, as described by the court in Westerland, likely applies here. And again, this is early in the stage of this litigation. I say likely applies here because the facts that I've been provided indicate that there was a second reading, a publication with a detailed summary identifying the first reading date as well as the second reading date. And that the ordinance was published and available before the challenged agenda in committee. That is, same here, the publication of the statute was prior to the publication as required under the Open Public Meeting Act. It was more detailed and provided the dates as well. Further, there is no indication anyone was unaware of the actions. Indeed, the plaintiff was there at all meetings until it was removed at the one meeting. Further, although the plaintiff asserts otherwise, the scheduling of the meeting in the middle of the day on February 14th, Valentine's Day, and Ash Wednesday is insufficient to this court's view at this early stage to demonstrate an intent to mislead in light of the published notices, advanced published notices, not just for the special meeting, but also the earlier notice of final reading for the ordinance on February 7th. The earlier notice was published with detailed respective date, final reading, along with details of the ordinance. So, the court finds that for those reasons that there's insufficient evidence of a defective agenda at either one of those meetings, such that the court could find a violation of the Open Public Meeting Act at this early stage. Again, the plaintiff has a high burden demonstrating by clear and convincing evidence, but for the reasons I just indicated, the court is not satisfied plaintiff has done. Having not found sufficient evidence of violation, that goes directly to the second two prongs, which I will address together. These next prongs requires that the underlying plaintiff's claim be well settled. That's Pro Super 90 NJ at 133. A fortiori, the court should withhold temporary relief when the legal right underlying plaintiff's claim is unsettled. Pivot. Third, the court should hesitate to order a preliminary injunction where material facts are controverted. An injunction typically will not issue when the material facts are in dispute. See Pro Super 90 NJ at 133. See also Citizens Coach Company versus Camp and Horse Railroad Company Super 20 NJ Equity at 304 and 305. This principle is important in light of the third requirement set forth in Pro, that is a preliminary showing of a reasonable probability of ultimate success in the merits. The failure to demonstrate a reasonable likelihood or probability of ultimate success in the merits has long counted heavily against the issuance of injunctive relief. See Ideal Laundry Company versus Limon, 107 NJ Equity 108 at 115 and 16 EA 1930. And that's exactly what I've just gone through and explained, that there's, in the court's mind, there are questions of the ultimate success that plaintiff will have with this matter, and whether actually it's a violation of the Open Public Meeting Act, given the law that I've recited and given at this early stage the facts that the court would be required to find in order to grant the restraints. I would also note that address the failure of the agenda, but there's also a question that is raised by the plaintiff with regard to his removal. He was removed from the February 14th meeting, and the Public Meeting Act, as cited by the plaintiff, provides in pertinent part that, quote, nothing in this act shall be construed to limit the discretion of the public body to permit, prohibit, or regulate the active participation of the public at any meeting, end quote. Plaintiff was ordered removed after he shouted at the mayor and council and spoke out of turn prior to the portion of the meeting devoted to public comment. Now, as I've indicated, I watched the video. The facts that I derived from that video are what I'm using here. There's no transcript that was provided, but in general terms, it appears that, and I'll use my term, there was a free-for-all going on, and it started on the council table where one councilman, Mr. Quinlick, stood and raised a point of order, and his point of order was voted on. He continued. Initially, I would note that the president of council said, have Mr. Quinlick removed, but other council members voiced their opposition to that, and it served as a warning, I guess, for Mr. Quinlick, and eventually Mr. Quinlick made his comments. When he attempted to make a second application for a point of order, it was denied because the first was voted on, and he sat down and conformed his behavior. And it was during this period of time that, and I believe it's the plaintiff, can be heard yelling. It's really only one voice yelling from the back, and I can't really understand what he's saying, but the council president says, have that person removed. The yelling continued, and it doesn't appear that Mr. Williams was removed at that time. It appeared that he continued to yell, and then they said again, please remove him, the words to that effect. At that point, you can see Mr. Williams being taken in front of the camera, where he continues to voice his concerns in a loud voice, and words to the effect that you're out of order, everyone's out of order, so I can be out of order, or something to that effect. And he was removed from the building. First, the court is satisfied that the Open Public Meeting Act does not prevent limitations, reasonable limitations by council and the discretion of the public body to permit or prohibit and regulate the participation of the public. Clearly, there's a government interest in maintaining order at a public meeting. Further, in this case, it is also clear that the plaintiff was not removed because of the content of the speech. Early in the meeting, it was the so-called ground rules were laid out by the president and council, where he indicated that this is the way it's going to go. We're going to have public participation later on. This is how much time is going to be allowed for public participation. And he also indicated that disruption would be addressed by removal. Now, I think this may be an important instruction in this matter, and maybe one, I don't know what the common practice of the council is. I've only had the pleasure of watching one meeting, but it appears from what Mr. Williams has said that this has been a common problem in the January 31st meeting, which, according to Mr. Williams, did not go well and had to be ended because of disruption. Under the circumstances, it's not unreasonable that the council would take steps to address disruption should it arise during the course of the meeting, which it did, and they addressed it, and apparently they were able to complete the meeting without having to end it as a result of disruption. And I'll also note that there is a strong protection of our First Amendment rights of speech. This is not to say that conduct at a public meeting cannot be unbridled. First Amendment rights are subject to reasonable time, manner, and place limitations. See Cox versus Louisiana, 379 U.S. 536 and 554. 1965, State versus Smith, 46 NJ 510 at 516 and 517, cert denied at 385 U.S. 838. 1966, and State versus Morgulis, that's M-O-R-G-U-L-I-S, 110 NJ Super 454 at 458 and 59, 12 Division 1970. The chair, in the court's view, must have the power to suppress a disturbance or the threat of one. And the power to quell a disturbance would be empty if its exercise cannot be met with still another disturbance designed to test the officer's judgment. Under the circumstances, and I'm reading from, that's a quote in State versus King 303 NJ Super 167, Appellate Division 1997, quoting State versus Smith previously cited. In any event, plaintiff has asserted that there was supposed to be a warning before he's removed. Well, under the circumstances at this stage, the court is not convinced there was not a warning. That the initial request by the President Council to have Mr. Williams moved, which doesn't appear to be carried out, and then a second request, which was carried out, had no effect. And it doesn't appear that, it appears that Mr. Williams, through his comments, was indicating that he was out of order knowingly. He indicated that everybody's out of order, so I'm going to be out of order. And I just want to comment on one thing that Mr. Williams said during the course of his presentation. He said, what kind of country would this be, or what would it be? It's a scary proposition that people would not be able to speak. And I agree. Were people suppressed and not able to speak in public meetings, that would be a very scary proposition. However, it would also be a scary proposition if there was no order in the meeting and no one was heard. To the extent that everyone was permitted to say whatever they want at any given time, as loud as they want, without order, that is also a scary proposition, and our Constitution does not require that. So I'm satisfied for those reasons that there's an insufficient basis for this court to find that the removal of Mr. Williams was a constitutional violation such that an injunction should be issued preventing any further actions. So the court, recapping, has gone through irreparable harm, although finding that irreparable harm is available and found where there's a violation of either constitutional rights or statutory rights of the Open Public Meeting Act. The question then became whether it was a violation. The court addressed agenda, the court addressed removal, found that there was insufficient evidence of violation such that plaintiff had met its burden for the second and third prong of Crow, that is, facts and law supporting the application were clearly proven and there's likelihood of success in the merits. It brings us to the last Crow prong, which is balance of the hardships. And John, is the final factor in considering the application of preliminary relief is a balance of the relative hardships to the parties in granting or denying relief, and that's Crow Super 90 NJ at 133. Even where the court has found a breach of covenant and irreparable harm, injunction may not issue. That is because the application of the appropriate remedy is always subject to equitable considerations, and that's Gilpin versus Jacob Bellis Realties, 47 NJ Super 26 at 30 Prohibition 1957. Where the court explained that the allowance of an injunctive relief is a discretionary matter that the court may be called upon to give or withhold relief depending upon variables, namely the circumstances of the case. In this case, in viewing the potential, as argued by the defendants, that the potential hardships to them would be significant, a member of council who was appointed to fill an empty spot of the mayor, who won election, was made at the, I believe it was the January 18th meeting, that if the court would avoid all those actions, he would no longer be able to participate and change the makeup of the council. Under the circumstances, plaintiff or defendants argue that that would be significant hardship. I agree. I would also note that there could be other significant hardships also asserted by the defendant. The defendant asserts that one of the ordinances that was voted on during these meetings was involved issues of certificates of occupancy for the sale of homes. Under the circumstances, this would leave the town without clear regulations or rules with regard to certificate of occupancy, impeding the sale of homes. And in addition, I note that the council sought to address, was seeking to address what it perceived as an issue with regard to ambulances, and to the extent that that would be impeded, that could also pose a hardship. On the alternative, the continued violation would be a hardship if there was a violation. The court found there really is insufficient evidence of violations at this point. Clearly, if there's what the plaintiff perceived as a violation, he has the courts open to him, and he can make an application to address that. But in any event, in balancing those hardships, the court is not satisfied that those hardships weigh in favor of issuing a relief sought. So in sum, the court has read and accepted the certifications for the purposes of this hearing, has watched the videotape, the pertinent parts of it, and found certain facts to apply in this hearing. Those facts found, the court has concluded that the plaintiff has not sufficiently demonstrated by clear and convincing evidence the necessary proofs to meet his burden under the Crow factors, and therefore I'm denying his application for relief. Now, I believe this was a preliminary application with a return date, so I'm denying the application. The matter would be converted to ordinary litigation. We'll proceed in the ordinary course when the defendant files an answer and be scheduled for a case management conference, and we'll proceed. So, having said all that, let me just ask the parties if they understand the court's decision. Before I wish them a good weekend and thank them for their presentation and their good papers. Papers were all good on short notice. Let me just ask if you understand the court's decision and have any questions. Beginning with you, Mr. Williams. Sir, do you understand the court's decision? Do you have any questions?
Your Honor, I do understand it, the court's decision, and I thank you for your consideration. Respectfully, I see the facts a little different than you did, particularly with regard to the removal.
I'm sorry, I can't hear you.
I'm sorry, Your Honor.
You're a little bit soft.
I'm sorry. I respectfully.
My age, I get a little hard of hearing too, so it may not be much your fault.
I'm trying to catch up. But respectfully, Your Honor, I disagree with you on what some of the facts were, but that's the nature of this as I understand it. And that's okay. Reasonable minds can disagree, but I think that I saw the facts considerably different, particularly as I was first person. But I appreciate your consideration and your relatively well-reasoned decision, and I appreciate you. Thank you, Judge.
Thank you, Mr. Williams. Have a good weekend. Mr. McGuckin?
Yes, sir.
You understand?
And we will be provided responsive pleading, whether that be an answer or a motion.
All right. All right. Thank you both. Have a good weekend.
Thank you.
Thank you.
Aye.